which the court is well aware of that citation, must be very careful to do so only by means of address from the bar or by means of an affidavit. Atebula says you must take the stand. If you're going to attack the state's case, just take the stand. They have not done that. And for that reason, I submit with respect, that argument should not even be considered by the court. In fact, Matebula takes it even further. It says, when you do that, when you start taking that stance, you take the stand and you must show to the court that on the balance of probabilities, you are most likely going to be acquitted. Have they done that before you, Your Worship? No. Well, Matebula is followed by many other cases. By the way, the Matebula decision is a 2010 decision which still stands. Volume 1, SACR, 55 brackets SCA. So it's from the Supreme Court of Appeal. It is the prevailing law. What His Worship needs to ask himself at this stage is whether the state has, one, placed a prima facie case. And if it has, court now must revert to section 60, subsection 4, paragraph A to E. Certainly. Perhaps before we even go there, I need to reiterate, Your Worship, with respect. Thank you. May it please the court. But as we deal with those grounds, section 60 says, I don't have to allege all of them. Thank you. We have alleged in the affidavit of Warrant Officer Mula that if the accused were to be released on bail, they would attempt to evade the trial. And he amplified this by saying, if you look at the sentence that they are likely to face, it might incentivize them not to attend trial. And that is what we...
How can I cure that if I fix bail?
If you fix bail, you will not cure that.
If I say they must report 5 days a week at a certain police station, will that not cure that? I'm just making an example. I'm not saying I'll say, or even 7 days. I can make that order. Every day you report it to Msunduzi police station between these hours. And if it comes to my attention you didn't report, I'm going to have to cancel the bail, keep you in custody. Does that not cure that?
I think it's a difficult one to cure. And naturally, many accused persons that come to this court who are released on bail with even much less stringent conditions, still don't come to court. So whether we have stringent conditions or not, and that is why when we supported this contention, we said perhaps you should look at the sentence as the incentive, not much the strict conditions or less strict conditions, but look at that sentence that they are looking at.
Counsel, this is a reception course. You can ask everyone. Schedule 6, Schedule 5 on a daily basis. I'm sure right now we're going to get maybe 5 counts of murder, 2 counts of murder. I'm saying, I here. But I just refuse bail because I think he might not come and attend his letter. We need to check. There's a lot of authority as to what is the interest of justice. Say, I refuse bail. What is it now? September, October, November, December, January, February, March, they go to trial. Once in custody, 174 granted. I need to put this in my mind as well. I need to think about that. I don't know the merits of the letter. You know, I mean, a lot of technical things happen in trial courts. This is just bail courts. Trial courts, a lot of things happen. 5 arresting officers. You find that they contradict themselves to a point. 174 is granted. I'm not saying that's going to happen, but I need to think about that. I cannot tell the plan on that. I need to think about that. So what I need to consider is, if you say there may be a flight risk, what can I do if I fix bail to make sure that they come and attend to this court? That is why I ask counsel for an applicant. Say I consider granting bail or fixing bail. Where are they going to stay? And in his own case, he never provided me with the alternative addresses, nothing.
And my argument to that is already here, that they did not believe that they are candidates for bail. And that is why they did not proffer the court any alternative address. They did not believe that they are candidates to be considered for bail. Because if they did, you would have been provided, sorry, Your Worship, the court would have been provided with an alternative address. But they did not believe that they are candidates for consideration to be released on bail.
Isigwebo singabantu ngabanani okungenzeka ukuthi umuntu futhi isigwebo sakhe siningi ngabasikhulu abaleke agcine engazange inkantolo agcine engatholakala. Futhi inkantolo lokho kungazama ukugcineka mangabe ukuthi ngoba kade sishilo kumele mangabe inkantolo inikeza ibail kumele kube ne-address eningana yona inkantolo ngeke ize ivele kunqobile ibail ngokuthi bacabangile ukuthi ningabalekela icala noma niyithole njengoba kuye kuvele mangabe kuthethwa icala kugcine abantu sebekhishwe phambili ngo-174 ngenxa yobufakazi obuthile kakhulu enkantolo ngoba-ke izinto mangabe sethethwa icala kuyaye kuveleke izinto eziningi ezi-technical ezigcina-ke inkantolo sebekungabaza bese kugcinela kwenzela u-174 njengoba-ke icala leli kutholakala ukuthi selisaphele okwamanje inkantolo mangabe inqabela ibail niyithole imihlelelo edokisini mhlawumbe kungaba yicala engathethwa ngokungabuzayo kodwa sonke lesikhathi izobe imfakile ibail uthola inqabele ibail bese idokisini uthola ukuthi icala seliyathethwa inkantolo yeseyikhipha phambili sonke leso sikhathi umndeni lokuqala ongafakana ingcindezi ngaphansi kwento njengoba-ke umuthi-ke ushushe sibanina bengingayithembi ukuthi bekulungele ukuthi niyidedele ngaphandle kwebail ngoba-ke anizange nize nikwenze lokho ukuthi ninikeze abombuso amanye ama-address amakhaya ningahamba nihlala khona bese benza ukuphela ngoba banina benibona ukuthi kwicala liqedlelile.
Of course, Your Worship, when you consider the bail here, there's a balancing act that His Worship has to consider. Now, let us look at what happens after the incarceration of the applicant. After they were incarcerated, project continued. There are no qualms, everything is in order. Let's suppose for a moment they are released in bail. Yes, you say they must not go there. But they will be outside to still have an influence. It's quite clear. Any argument that they were ringleaders or instigators is supported by the fact that after their incarceration, project continued without any problems.
I've never had any suggestion by the state or the IO that they were the ringleaders, that's number one. Say I feel strain, I say 100 kilometers away from Baklima. How are they going to influence the son?
Well, communication cannot only be done person to person. There are many other means of communicating.
I don't want to subject ourselves to speculation. I mean, the fact that they might.
But is it not reality, Your Worship, that after incarceration, the project continued? That's the reality, that's the evidence. But before
also on the same paper, you said there were more than 30. So 5 arrested, what about the other 30? They could influence, they would have.
But have they done that? Because when he was asked, say, after the arrest, did that 30 or 1,000 or million people, did they go to the construction site? No. What does that suggest then, Your Worship? So in all probability, the argument that these are instigators is definitely supported by the facts. In just almost at the tail end of my argument, Your Worship, their affidavits spoke more about their personal circumstances. I have that responsibility, I have this responsibility, I'm taking care of elderly and all of that. But I wish to highlight the following to the court from the book titled Bail, A Practitioner's Guide, 3rd edition, written by John van der Berg. At page 152, paragraph 6 to 7, it reads, the fact that the accused has dependents to support or business to run is of little consequence in the assessment of his bail prospects, except in as much as those factors point to the stability on his part, which reduces the risk of abscondment. So from these papers, you don't hear that what they're running business.
Yeah, and also it's fine. I mean, they are the applicants. I was doing a decision on Monday, Mr. Mayor, for a schedule 6 bail. That's you better honest to show me who are you supporting, who's the mother, who's the child. It's an application proceedings. You need to tell me everything. I don't have to ask for those things.
Which you don't have.
You know, so that I'll consider that as well.
Maybe.
I mean, you can't tell me that I'm the sole breadwinner, I have 5 children, not even the birth certificate attached to the application. What must I say?
It is left open there.
ukuthi yena unebhizinisi alivanayo uma ngabe emphakathini lizophazamiseka. Inkantolo konke lokhu kwamaphuzu inkantolo ezowabhekelela ngoba yena kwanina lento ekade ngisho angizange kube khona ubufakazi benisekela ngayo ukuthi njengoba lunethele mina unakekela ekhaya uma usekhulile kulethwe i-ID yakhe ney'ngane lezi engikhuluma ngazo kulethwe ama-birth certificate kuzoqinisekiswa ngempela iminyaka yalabantu engikhuluma.
Exactly where I was going. In fact, in S versus Yanda 2000, Volume 1, SACR 237, brackets TK, as well as S versus Farmas, which is 1996, brackets 1, SACR 528, brackets T, it was stated that in Section 6011, the personal interests of the accused are clearly secondary, and the interest of society in a proper and effective administration of criminal justice system plays supreme. And in this case, I submit, Your Worship, that in the consideration of bail, whether you consider their personal circumstances, the Honorable Court should consider that the proper effective administration of criminal justice system plays supreme against their personal circumstances. Lastly, I think I need to deal with the issue of previous convictions in respect of applicant number 2 and applicant number 4.
What do you say on the first and the paragraph 10 of the application? They say, if I fix the 500 rand, you're going to serve on that?
500 rand one is not even consummate to the offense. I think that's what I would say. It's not even consummate to the offense itself. Section 6011B places an onus on the applicant before court to honestly inform the court, not only him, it says even the legal advisor, inform the court of their previous convictions.
Why they did not disclose their previous conviction? Do you accept the explanation?
No. To which I say, Your Worship, it's startlingly bizarre. It's an afterthought, and especially if one considers in the manner in which it is crafted in their papers. It is submitted. It smacks of an afterthought, manufactured, tailored explanation in an attempt to hide their initial intent, which was to be dishonest to the Honorable Court. I do not believe, I submit, Your Worship, that they were not aware of their previous convictions. It is quite improbable for something that would have taken place in their lives. I mean, anyone who comes to this august institution, there is no way you can forget the day you came to court. It's impossible. There is no way you can forget. Everybody fears to come to court. So it is impossible, rather improbable, that it must be expected that they forgot about. In fact,
and I think the explanation is that we went there, but I didn't think that we were convicted. Because I got a question on this charge, I was like, oh yes, I'm going home, probably I won the case. And then same thing to applicant number 2, that I'm not even going to jail, so I won the case. I think that's what I gathered.
I think His Worship must examine the explanation further than that. Because the explanation proffers a plethora of explanations. And the question that I am now asking myself, which one is the Honorable God going to take? So it's not only one reason. At one moment, in fact, they now go to a point when my learned colleague addresses of denying it, because they say the state did not prove it. So which one are you going to accept in the explanation? One, no, state did not prove the previous conviction, which is flawed. I shouldn't prove it. That is not where we are at now. They should tell us Section 6011B requires them to do so. All right, no, it happened a while ago, 28 years ago, so I've forgotten about it. Oh no, there's an issue of language. I did not understand him. The affidavit consists of more than 5 pages. And the only aspect in the use of language relates to their previous convictions. Certainly this is a lie.
Niphinde futhi athi umuntu ngasese ngikhohliwe ngenxa yokuthi-ke lento yenzeka kudala, mina ngisasemncane futhi njengoba ngadedelwa ngangaya ey'tokiseni ngangiyitshela ukuthi-ke angiyinto icala ingakho abantu bami. Phinde futhi kule isikhathi sesithathu nithi-ke mina ngalesikhathi-ke umeli wenu uyakhuluma nani kube kuphazamiseka ulimi ngoba-ke ekhulumisini ngikhuluma isiZulu. Uthi-ke konke lokho kuyinto nje ekhombisa ukuthi amanga benenza ngamabudo yinto njengoba-ke nani nibonile ukuthi-ke neqamba amanga lapho ngonkantolo ningazama ukuyikhamba kanjani kuyinto ukuthi-ke iyona incazelo enkantolo engingayamukela ukuthi-ke ngabe beningazi abombuso bahlelekile ukuba la leli cala noma kuzakahle inkantolo isafanele ingokubazi ngeke kwenzakala.
This is not a minute thing, Your Worship, at all. In fact, in Yanta, as I've cited Supra, as well as the decision in Rudolph, S.S. Rudolph, 2010, Volume 1, SACR 262 brackets SCA, the court said that in considering this question, the court may take into account the fact that accused knowingly supplied false information at the time of his arrest or during the bail proceedings. So there was a false information supplied before this honorable court. And that, I submit, with respect, Your Worship, may lead to undermine, jeopardize the objectives of the proper functioning of the criminal justice system. And perhaps, therefore, that should also be a factor to be considered for why bail should be denied. Lastly, Your Worship, I do not intend to hype up the court. Extortion on economic sides is a reality. And I'm not saying to His Worship, you must decide this bail application on the basis of that reality. What I'm pointing out is that extortion on economic sides is a serious offense. It by no means can be considered as a lesser offense. And that is why it is also read in the Criminal Law Amendment Act, aptly referred to as the minimum sentences. It's under 51(2), which attracts a minimum sentence of 15 years. And that speaks to the seriousness of this offense. But it is also on the rise, not only in this jurisdiction, but countrywide. That is what we are faced with. And at some point, reality must be knocked on somebody's head that these offenses cannot be tolerated, and that those who are found to have committed them will appear before this court. Yes, I know we are not deciding on their guilt now, but they must be treated. It is a serious offense. It must not be trivialized by no means by the Honorable Court. Are they candidates to be granted for bail? I submit no. That if they are released on bail, it is likely to cause a situation where that project stops. If that project stops, people will be out of employment. If people are out of employment, that is economic calamity in our country. Nothing further. Thank you.
Yeah, I was going to say, I can't wait for lunch today.
Yes.
I have a meeting during lunch. So can you come back at 2?
Let's go.
And tell your clients before they start shouting on you, because they always howling when I postpone the matter. You won't get a decision today.
No,
so that everyone understands.
I think the message is going around. We didn't get to Friday.
Yeah. So every time we postpone a matter, there's some noise coming out.
Okay.
So we won't finish today so that they know I won't give a decision
As copies.
on Friday.
God please.
Sukman. Siyela James, ukuya ngosuku. Vamos
Under cross-examination, he says this is general knowledge, not even sourced from the complainants. And certainly with the following the requirements of tender processes and everything else, this is only unique to the actual participants in the tender process, in particular WSMG group. It's not general knowledge. Paragraph 7.1, 7.2 is framed in a fashion as if the investigating officer was present at the relevant times. It's no allegations, and this is the information I received from the complainants. And why I raise issue with this, because his affidavit is prefixed and within the context of paragraph 3, it falls within my personal knowledge.
Counsel, I think this point was dealt with in cross-examination.
Yes,
in your address earlier on.
Yes.
And I will make it. I will make it a proper ruling in that regard.
Okay.
In my judgment.
I'm going to progress.
Yes, please.
Thank you. The issue regarding the accused not taking the stand, and there's no basis of the defense. It is trite. This is a bail application. The issue of the accused guilt is not a focus of attention. The issue is whether they would stand trial. I may add that the accused version, or as per the affidavit, they said they're going to plead not guilty. They do not wish to disclose the basis of the defense at this stage, in essence because the allegations, the full extent of the allegations by the state are not known to them. Is their right? So it's not correct that the accused, despite a prima facie case, have not raised any defense. They said they're not disclosing the basis of the defense, which is their right. It's interesting in the case that I've cited, which I will, as promised, hand into the court, the Tishani case versus the state, where the appeal court actually found that the magistrate misdirected himself by drawing an adverse inference from the fact that the accused said he's pleading not guilty but did not take the stand to disclose any aspect of his defense. At paragraph 28, which I read previously into the record, but I'll just highlight the relevant portions of the same case. He indicated that he was not going to tender a plea of he indicated that he was going to tender a plea of not guilty at the trial. In any event, the accused defense is not a factor enumerated in section. The main purpose of bail is for the court to examine whether the accused will stand trial. At page 30, at paragraph 31 of that case, where the court was placing reliance on the cases, my learned friend also made mention of S versus Dlamini, S versus Gladla, he made mention of S versus Dlamini, but it's together with other cases which were dealt with simultaneously by the Constitutional Court under citation 1999, volume 4, SA 623 CC at paragraph 11 of the Constitutional Court, reiterating the fact that it is the task of the trial court in bail application, the inquiry is not concerned with the question of guilt. That is the task of the trial court. So I would submit. That should pay to my learned friend's submission, contention that an adverse inference should be drawn from the accused failure to set up a defense. My learned friend's contention that the issue of the presumption of innocence is only relative to the trial is correct. But equally correct is that if the question of the accused's guilt is not an issue of relevance to the trial, rather than the issue of whether they stand trial, it in a very indirect way confirms that you cannot start off on the assumption that the accused are guilty, and you make the point of reference being the incidents being on the 22nd and 23rd as the offense in which they threatened the complainants as the basis to draw your conclusion that they would interfere with the witnesses. My learned friend is contended that the state has presented a prima facie case, but the accused and the same breath that said we're pleading not guilty, we're not disclosing the basis of our defense. But how do you assess the level of the state's case and say it's a prima facie case when their founding affidavit is extremely problematic, which includes material contradictions from the investigating officer relative to the issue of where the accused were arrested. I would submit that stating a prima facie case based on hearsay evidence, which we don't know because of the uncertainty in way the affidavit has been formulated, you cannot reach the conclusion that there is a prima facie case on any level. Now, my learned friend made general submissions regarding that the accused would evade justice. I think the court would pay to that in terms that these were generalized assumptions. My learned friend has indicated that the project has continued now that the accused have been arrested. And that they were the ringleaders. But none of this emerges even from the affidavit of Warrant Officer Malapui, They were not termed as the ringleaders. In fact, in his own words, they are applicants and the co-perpetrators, being that there were other people that were equally guilty, if you could put it that way, or equal participation in the offense.
Did you not cover that in his oral evidence when he took the stand? He was under oath.
Well, covered what, Your Worship?
That's the project is proceeding.
Well, if the project is proceeding, now I will get to that, Your Worship. I'm talking about the ringleader story. Your Worship, the argument regarding that the project continued because the accused were arrested and therefore they're the perpetrators who work equally, if one considers that if the real perpetrators know that the accused were arrested, I mean, logic and common sense that they're stupid enough to now to go and commit another, go back to the project would be a sign that the wrong persons were arrested. It's most of the times, arrest the wrong person, the culprit will keep quiet and not do anything for the time being. And in any event, the uncertainty of the, or the compromised state of the accused, pointing out, coupled with the fact that there are at least 30 other people outside, would mean that even if the innocent or guilty, the accused, effect of any, if the accused are innocent, that the real perpetrators would not go back to the thing, to the crime scene. Worship, the state made issues regarding the personal circumstances of the accused, that it was not corroborated. Now that's a difference between saying I paid, for instance, and I produced the receipt, hypothetically. But the fact that the accused's personal circumstances have not been challenged, that they are primary caregivers to certain family members, and they are, that's the full stop, because the state has not challenged that in any way. So corroborating the claims that the primary caregivers and breadwinners does not detract from the fact that their evidence on the matter is final, and that's the full stop to it. The issue of the accused, particularly accused number 2 and number 4's previous convictions, there was a replying affidavit that was supplied. And the sum total of the state's response to that affidavit was that they had no comment by Malapa, and the state didn't take that matter any further. So the explanation of the accused regarding why they did not reveal their previous conviction is an explanation that has been tendered and in no way challenged. That's the only version the court has got. An explanation of two young men at age 17 went to court. When they went home, instead of going to jail, they thought they were acquitted. And as I said, they were not benefiting in any way by not disclosing their previous convictions. And therefore this validates, the bona fides of them not disclosing it in the circumstances described. That should be a full stop on that issue as well. My learned friend submitted that the explanation was inherently improbable. It's unbelievable and to that extent. Your Worship, does not alter the fact they tendered an explanation and it's not been challenged. So belated comments on the improbability of that does not play a part. There's certainly nothing so far-fetched in the explanation tendered that this court can reject it. Submit that in totality the accused have established on a balance of probabilities that it's going to be in the interest of justice that they be released on bail. I may add that the accused indicated that they were not going to interfere with the state witnesses. And so the issue of alternative addresses were not canvassed during the course of the matter. However, this has been sorted out at this stage. Your Worship, the accused have furnished me with certain alternate addresses. They have not contacted the family members, but I've spoken to my learned friend, and together with the investigating officer, the list would be provided to the investigating officer to expedite the matter. The accused would be kept, as I understand it, at the Hammersdale police station to have accessibility for the investigating officer to verify those addresses.
Where are these addresses?
Your Worship, one is in Howick West, one is in Changa, two in Changa, one is near Lion Park. Yeah. And one is in Gatorade.
Gatorade?
Yeah.
Gatorade is owned by China. Isn't it the same area? You see, the one in Howick, I may consider Howick is far.
Your Worship, as said, it was a list that was done under pressure we can look at it. Give the investigating officer further possible addresses. But as I indicated, that the investigating officer says that he will keep them and arrange for them to keep at a police station that is near, so he can do the running around before
You have to be fair to the investigating officer as well.
Yeah.
If you can provide him with whatever you need to provide him today, and then he takes it from there.
No, I will give him certain.
Right.
Thank
Do
you.
you have anything further?
Nothing further. Thank you.
Mr. Mata? Then
Just maybe two aspects.
it will never end. When I want to reply and then
Just two
That's
aspects,
fine.
and then
no,
so that the record does not have an incorrect proposition of the arguments by the respondent.
yeah.
On this issue of paragraph number 3 of the affidavit by Warrant Officer Mula, I wish to end it in the following. The contents of this affidavit are, to the best of my knowledge, true and correct, and the facts contained herein fall within my personal knowledge. 1. By that, it's information that he is now aware of, as he has been informed by the witnesses. That's what that means. But that is not accepted. It goes further and says, unless stated and or the context indicate otherwise. Now, what is the context of this affidavit? It is done in the process of bail application. And I submit, Your Worship, that is how you should read the meaning of that. It is untenable that anyone could expect this court to construe the evidence of Warrant Officer Mula to suggest that he was presently there when all this took place. He could not have been there. He is merely an investigating officer whose information is based on what is in the police document. I did not say to this court, second issue, I did not say, well, the accused, rather the applicants, were supposed to or did not put up a defense. I did not say that. I said, the case of Matebula, and I invite my learned colleague to go and read that case. Matebula's case says, when you attack the strength of the state case, the next step that you need to do as an applicant, show to the court that you will be convicted. It's not me. It's not because I love to say these things. That's what the law says. So when I raised this, I wasn't saying you must put up a defense. I'm not saying that. I'm saying when you start to poke the evidence of the strength of the state case, the applicant needs to do more. That's what I was saying. It's there, it's the law.
wazisho izizathu zakhe ngaphansi kwesikolo hayi ukuthi ke mina ngibesho ukuthi nani bethele njani bethi kakhulukazi mina ngingabe ukuthi ngihlasela okunye kena umphakathi ngingekho umphakathi befanele ngiyibone kodwa hayi ngoba kodwa ke icala leli akazosebenzisa into ekhindizekile khona bephikisa
Lastly, as I sit down, Your Worship, it is misleading to say to this court, Warrant Officer Mulapo said his evidence is of general knowledge. It's misleading. There was a specific question that he was asked, which related to whether he personally experienced the issue of floods, because this was coming from the background of the issue of floods. And then he, in his reply, he then said, well, the fact that KwaZulu-Natal, the countrywide, faced floods or heavy rains, and as a result there were damage to infrastructure, is a matter of general knowledge. That's what he said. It related to that. So the argument that his version now, or his evidence, moved from personal to general knowledge is misleading. Thank you, Worship. I've got nothing to
Your Worship, the issue of personal knowledge, I think, has been canvassed in great detail. There's a Supreme Court authority as to how affidavits need to be presented. Yeah, he's supposed to say the source. And the context does not indicate any otherwise when you're reading his affidavit. So I think that addresses that issue. The accused had stated categorically they did not wish to disclose the basis of the defense, and that's the end of the matter. But however, what was attacked and what was shown lacking was the state's case in a number of occasions, including the pointing out where it occurred and who was involved. The issue. My question to Warrant Officer Mulapo was very specific, and it related to specifically the issue of the protocols that were followed. And his response was it was general knowledge. It wasn't general knowledge about the issues regarding the rain and the floods and everything else. And what was concerning about Malapa's evidence was that he also took into account not even hearsay but rumors that accused number 4 stabbed somebody. Rumors that go back 20 years. So, in conclusion, at the end of the day, you present your affidavit in the wrong fashion. It cannot be remedied. Affidavits are evidence, they cannot be amended. Nor can they be amplified or any incorrect aspects be rectified if you take the stand. What it does, as I pointed on the last occasion, it proves that you're a liar. I have no further request. Thank you very much.
What's on, Mr. Chetty? 20 September, Friday for judgment.
I think it's 20th.
All right, Your Worship.
20th. 20th.
20.
20th, yeah. 20th. Friday is the 20th.
This Friday.
Yeah.
This Friday.
Can you arrange 11:30?
As the court pleases.
In order, in order.
As the court.
Gentlemen, can you please stand up? Alright, gentlemen, your matter is once again postponed since 20 September, this week Friday, for the judgment on bail. Please stand up straight, Mr. Thank you. 20 September 2024 for the judgment of this bail application. So you will be in custody until the 28th of September, and we have arranged that we will meet at 11:30. Right. So please just sort out the issue of the addresses and yeah.
Your Worship, if you may just request further that the detention warrant to indicate Mpumalanga police station.
Well, that's a problem because, Mr. Mayor, how does it happen? You require a written request from the commander,
Yes.
if I'm not mistaken.
Yes.
Yeah. Or a captain. Do you guys have that?
So that the arrangement is actually
Is that so?
That's correct, Your Worship.
Made
But
with
I have communicated with the station commander of
Hammersmith.
Candidacy.
Yes.
I have spoken with him and he had no issue.
Very well then. Alright, gentlemen, you may be excused. I'll attend to the J7s because it's Kanyina. Alright.
Sorry, Your Worship, I promised to hand in.
Yes, you will be guys remanded in Hammersmith police station so that the investigating officer will attend to verify your addresses. Thank you, Mr. Chetty. Do you guys understand? Any questions? Your attorney will address you. All right. Anything else? See, I need those addresses to consider my decision. I'm not saying I'm going to fix bail or refuse bail. So it's up to you. Give them the address that you know you've been reasonable, taking into account. I don't know where it's Clember. I don't know where it's what. Thank you. You may be excused then. Right, Mr. Mata, I'll see you guys on Friday, 11:30. Alright, thank you.